CMFAS, Module 5, Chapter 3, Financial Advisors Act and Financial Advisors Regulations, Conduct of Business, Power of Authority, and Offenses. This chapter is a continuation of Chapter 2 and covers the sections of the FAA relating to the conduct of business, powers of authority, and offenses. Obligation to disclose product information to clients. A licensed financial advisor must disclose to every client and prospective client all material information relating to any designated investment product that he is recommending, including the terms and conditions of the designated investment product, the benefits and the risks, the premiums, costs, expenses, fees, or other charges. If the designated investment product is a unit in a collective investment scheme, the name of the manager, the relationship between the licensed financial advisor and the manager. If the designated investment product is a life policy, the name of the licensed insurer under the life policy, and the relationship between the licensed financial advisor and the insurer, and such other information as the MAS may prescribe. Statements by licensed financial advisors. The principles on the type of statements that a licensed financial advisor can make are highlighted in the FAA, which states that no licensed financial advisor shall, with intent to deceive, make a false or misleading statement as to payable amount of a proposed contract, or the effect of any provision of a contract or a proposed contract, or the connection with the provision of any financial advisory service. Making a misleading statement includes omitting to disclose any material matter. Contravention. Any licensed financial advisor who contravenes the above rules shall be guilty of an offense and subject to a fine not exceeding $50,000 or imprisonment for a term not exceeding 12 months or both, even if a contract does not come into being. Recommendations by licensed financial advisors. The FAA provides that licensed financial advisors must have a reasonable basis to make a recommendation with respect to any investment product to a person. A licensed financial advisor is said to have a reasonable basis if the recommendation is based on considering and investigating the investment objectives, financial situation, and particular needs of the person. If a licensed financial advisor does not have a reasonable basis in recommending an investment product to a person and the person suffers loss or damage, the licensed financial advisor is liable to pay damages to that person. Receipt of client's money or property. The FAA provides that client's money or property means money received or retained by or property deposited with a licensed financial advisor in the course of his business, for which he is liable to account to another person. The MAS may, by regulations, determine the manner in which a licensed financial advisor may receive or deal with clients' money or property, or prohibit the licensed financial advisor from receiving or dealing with clients' money or property in specified circumstances or activities. The FAA states that a lien or claim on client's money or property in any account established by any licensed financial advisor shall be void, unless the monies in the account are for fees due and owing to the licensed financial advisor. A charge or mortgage on client's money or property in any account established by any licensed financial advisor shall be void. Obligation to provide information to the MAS. The MAS may require any licensed financial advisor to furnish it with information in writing about any matter related to its business, whether carried on in Singapore or elsewhere. Any person who does not comply with this requirement without a reasonable excuse shall be guilty of an offense and subject to a fine not exceeding $25,000 or to imprisonment for a term not exceeding 12 months, or to both. And in the case of a continuing offense, to a further fine not exceeding $2,500 for every day or part thereof, during which the offense continues after conviction. Insurance broking premium accounts. The FAA provides that every licensed financial advisor who receives any insurance monies shall establish and maintain a separate account with a licensed bank for its life insurance broking premiums. That means life insurance broking premiums must be kept in a separate licensed financial advisor account with a licensed bank. The licensed financial advisor serves as a middleman who helps with the payment of the insured's premiums and the insurer's claims. A financial advisor shall pay into this separate premium account all monies received from an insured, premium, or an insurer, claims. No financial advisor shall withdraw monies from such a separate premium account, unless for any of the following circumstances. Any payment to or for a person that is entitled to receive payment of the monies, including the financial advisor itself, so far as it is entitled to receive this payment. Any payment to or for an insurer in respective amounts due to the insurer, under or in relation to a contract of insurance. Any investment by way of deposits placed with a licensed bank, or any repayment of monies that were paid into the account in error. For instance, if a client makes a claim on a life insurance policy and the insurer approves, then the insurer is going to pay the client. The claim may be deposited into the licensed financial advisor's segregated account first. Then, the licensed financial advisor shall withdraw the money from this account and pay the client. Refund of loss on investment. For the third kind of withdrawal, investment deposits placed with a licensed bank. The FAR provides that a financial advisor shall pay monies received from the realization of such an investment into its separate broking premium account. If the amount of realization received is less than the amount of monies invested, the financial advisor shall refund the difference. That means the FAA doesn't allow negative interest rates. The financial advisor shall pay for the difference. Retention of interest and income. The FAR provides that before October 1st, 2002, a financial advisor can retain interest or other income arising from any payment during the credit period, which is due to the insurer under or in relation to a contract of insurance. But after October 1st, 2002, such interest or income shall belong to the insurer, but may be retained by the financial advisor for its own benefit with the insurer's prior consent. After the credit period, such interest or income shall not be retained by the financial advisor and shall be paid to the insurer immediately. Credit period means the payment period due to the insurer, or 90 days from the date of commencement of cover of the contract of insurance, whichever is earlier. Negotiation and placement of risk with unlicensed insurers. The FAA stipulates that licensed or exempt financial advisors shall only negotiate a contract of insurance with an insurer, who is a licensed insurer, whether directly or indirectly. The contract of insurance above shall not apply to reinsurance, businesses relating to risk outside of Singapore, or such other risks as may be prescribed. This is a prohibition against the negotiation and placement of risk with unlicensed insurers, except where specifically permitted by the MAS. Only insurers licensed by the MAS under the Insurance Act can carry on insurance business in Singapore. Individuals are not prohibited from purchasing life policies from unlicensed overseas insurers. However, financial advisors are required to seek the approval of the MAS. This is to ensure that no financial advisor is being used by unlicensed overseas insurers to assist them in writing domestic Singapore risks, since unlicensed overseas insurers are not allowed to carry on insurance business in Singapore. Representations by licensed financial advisors. A. Proposed contract of insurance. The FAA provides that no licensed financial advisor shall, with intent to deceive, in relation to a proposed contract of insurance, provide the insurer with a form that is false or misleading in the material particular, omit to disclose to the insurer any matter that is material to the proposed contract, advise or induce the intending insured to fill up a form that is false or misleading in the material particular, or advise or induce the intending insured to omit to disclose any matter that is material to the proposed contract. B. Claim under a contract of insurance. The FAA states that no licensed financial advisor shall, with intent to deceive, provide the insurer with the form that is false or misleading in a material particular, omit to disclose to the insurer any matter that is material to the claim, induce the insured to fill up a form that is false or misleading in a material particular, or advise or induce the insured to omit to disclose any matter that is material to the claim. Contravention. When proposing or claiming a contract of insurance, a licensed financial advisor shall not deceive the insurer with the intent through false or misleading statements, or omitting to disclose any material matter, or induce the insured to do the same. Any licensed financial advisor who contravenes the rules shall, notwithstanding that a contract of insurance does not come into being, be guilty of a fine not exceeding $25,000, or imprisonment for a term not exceeding 12 months, or both. How to avoid conflict of interest situations. A financial advisor should act in the best interests of its clients in providing services. Where a conflict of interest situation cannot be avoided, the financial advisor should ensure that its clients are treated fairly and equally. To do this, a financial advisor must disclose potential and actual conflicts of interest to its clients or prospects. When sending a circular or written communication in which he makes a recommendation, a financial advisor shall include a clear, concise statement of the nature of any interest related to him in the specified products or in the acquisition or disposal of the specified products, and such interest of its related persons. For example, if the financial advisor intends to sell a product to its client that its holding company provides, due to the holding company's relationship as the financial advisor's related person, the financial advisor shall disclose the interests of its holding company in the product to the client. Before establishing a client relationship, a financial advisor should fully disclose all material information or facts that may compromise its objectivity or independence, or impair its ability to make unbiased and objective recommendations, and disclose to the clients its relationship with the financial institutions in respect of the products it provides advice on or recommends. How to defend against failure to disclose conflict of interest. Disclosure is aimed at helping the customers to make informed decisions. A licensed financial advisor is guilty if it does not comply with the disclosure requirement. A licensed financial advisor may not be guilty if it can prove that it was unaware of the conflict of interest in the specified products or in the acquisition or disposal of the specified products. Contravention. The FAA states that a licensed financial advisor who contravenes the conflict of interest requirements shall be guilty of an offense, and subject to a fine not exceeding $25,000 or to imprisonment for a term not exceeding 12 months, or both. Register of interests in listed specified products. The MAS requires all licensed financial advisors and its representatives who provide financial advisory service in respect of listed specified products to maintain a register of its interests in the listed specified products. To do this, a financial advisor shall maintain a register of his interests in listed specified products, enter in the register particulars of the listed specified products and his interest within 7 days after he acquires any interest in the listed specified products. Retain that entry in an easily accessible form, including electronic form, for not less than 5 years after such an entry was first made, and ensure that the register and a copy of the register are kept in Singapore, and maintain the records of such places. In the case of an individual, at his principal place of business, or in the case of a corporation, at any of its places of business. When there is any change, enter the particulars of the change in the register within 7 days, and retain the entry for 5 years. Definition of unsecured advances, loans, and credit facilities. Unsecured advance, unsecured loan, or unsecured credit facility includes any advance or loan made without security, any advance, loan, or credit facility made with security, but the amount exceeds the value of the security, any advance, loan, or credit facility made by another party, but guaranteed or performed by the licensed financial advisor to any of its employees, and any credit facility without security, whether drawn down or not. Security here means collateral, like deposits or cash, or any valuable that offers a guarantee. Conditions for granting unsecured advances, loans, and credit facilities. The FAR states that a licensed financial advisor shall not grant any unsecured advance, unsecured loan, or unsecured credit facility that exceeds $3,000 to any of its employees, including the director, officer, and representatives, and to any of its directors who are not its employee. How to appoint a chief executive officer or director of a licensed financial advisor. Licensed financial advisors are required to seek the prior approval of the MAS via the submission of Form 11 for the appointment of its chief executive officer, for the appointment of its director, for changing the nature of a director from non-executive to executive. The requirements do not apply to the appointment of a director of a foreign company who is not directly responsible for the financial advisor's business in Singapore. What will be considered when appointing a chief executive officer or a director? The MAS determines whether to grant its approval in regards to the following criteria: whether the licensed financial advisor has provided the MAS with required information relating to the appointee or director, whether the appointee or director has had a prohibition order made against him that is still in force, has been convicted of an offense involving fraud or dishonesty under the FAA, is a fit and proper person, is financially sound or unsound, whether he is an undischarged bankrupt, whether his judgment debt has been returned unsatisfied, whether he has entered into a compromise with his creditors, and relevant information about his educational qualifications, experience, or expertise, his financial standing, his past performance, and whether there is reason to believe that the appointee or director will not conduct himself with professionalism or act ethically in discharging his duties. What are the duties of a financial advisor and its CEO or director? A licensed financial advisor shall comply with all the laws and rules governing the operations of the financial advisor, and in a manner that is proportionate with the nature, scale, and complexity of its business, implement and ensure compliance with effective written policies on all operational areas of the financial advisor, including the financial advisor's financial policies and accounting. In order to protect investors and reduce the risk, put in place compliance functions and arrangements, including specifying the roles and responsibilities of officers and employees in helping to ensure compliance with all applicable laws, codes of conduct, and standards of good practice. The risk includes incurring legal or regulatory sanctions, financial loss, and reputational damage. Identify, address, and monitor the risks associated with its business activities. Ensure that its business activities are subject to compliance checks. Set out in writing the limits of the discretionary powers of each officer, committee, subcommittee, or other groups of persons. Keep a written record to monitor the compliance. Ensure the accuracy, correctness, and completeness of any report, return, or statement submitted to the MAS, and ensure effective controls and segregation of duties to mitigate potential conflicts of interest that arise from the operations. In order to determine whether the Chief Executive Officer or Director has failed to discharge his duties, the MAS regards whether he has ensured the financial advisor's compliance with the above-mentioned duties. Removal of officer of a licensed financial advisor. The fit and proper criteria is a continuing requirement. If any officer of a licensed financial advisor does not measure up to this benchmark, the MAS may direct the company to remove such an officer from its office for the public interest or for the protection of the investors. Power of the MAS to issue written directions. In the interests of the public or for the protection of investors, the MAS may issue written directions, either of a general or specific nature, to any licensed financial advisor, to any exempt person, to any representative, or to any supervisor of a financial advisor. Written directions include a circular or notice. What is a prohibition order? The MAS has the power to issue a prohibition order. The objective of a prohibition order is to keep unfit persons from engaging in any or all of the financial advisory services regulated under the FAA, or taking part in the management or acting as a director or substantial shareholder of a licensed or exempt financial advisor. An order will be placed only in cases where very serious offenses have been committed. A prohibition order does one or both of the following: prohibit the person from, whether permanently or for a specified period, providing any financial advisory service or providing such service in specified circumstances or capacities, or taking part in the management, acting as a director, or becoming a substantial shareholder of a licensed financial advisor or exempt financial advisor, and include a provision allowing or prohibiting the person, subject to any conditions specified in the order, to do specified acts or to do specified acts in specified circumstances. Where a prohibition order is made against a person and notified to a licensed financial advisor or exempt financial advisor, The licensed financial advisor or exempt financial advisor shall not employ the person to provide any financial advisory service or use his service. Contravention will be guilty of an offense and subject to a fine not exceeding $50,000. The MAS may vary or revoke a prohibition on its own initiative, or if the person lodges with the authority an application accompanied by the required documents or fees. Under the first circumstance, the MAS may give written notice to the person. Any person aggrieved by the decision of the MAS to vary a prohibition order against him may appeal in writing to the minister within 30 days. Power of the MAS to publish information. The MAS may publish information relating to all or any of the following: the lapsing, revocation, or suspension of the license of any person, the removal of any officer, the making of any prohibition order against any person, the acceptance by any person of an offer to compound an offense, the reprimand of any person, the revocation or withdrawal of any exemption granted under the FAA, the conviction of any person for any offense under the FAA, the conviction of any licensed financial advisor for any offense, whether in Singapore or elsewhere, and any other action as may have been taken by the MAS against any person under the FAA, and any other information as the MAS may consider necessary or expedient to publish in the public interest. Who is an officer? An officer in relation to a body corporate means a director, member of the committee of management, chief executive, manager, secretary, or other similar officers of the body, and includes a person purporting to act in any such capacity. An officer in relation to an unincorporated association, other than a partnership, means the president, secretary, and members of the committee of the association, or a person holding a position corresponding to that of the president, secretary, or members of a committee, and includes a person purporting to act in any such capacity. Offense by officers. Where an offense committed by a body corporate has been proven with the consent of its officer, or to be attributable to any neglect on the part of its officer, both the officer and the body corporate shall be guilty of that offense. Any officer of a licensed financial advisor who fails to take all reasonable steps to secure compliance with any provision of the FAA, or the accuracy and correctness of any statement submitted to the MAS, or such other person as may be required under the FAA, shall be guilty of an offense, and subject to a fine not exceeding $100,000 or imprisonment for a term not exceeding 2 years, or both. Defense on reasonable grounds. In any proceedings against an officer, it shall be a defense for the officer to prove that he had reasonable grounds for believing that any person was charged with the duty of securing compliance with the requirements of the FAA, or another person was charged with the duty of ensuring that those statements were accurate, and that person was competent to discharge that duty. Then the officer shall not be sentenced to imprisonment, unless in the court's opinion he has committed the offense willfully. Falsification of records. Any officer, auditor, employee, or agent of a licensed financial advisor or an exempt financial advisor who willfully makes a false entry, omits to make an entry, or alters, extracts, conceals, or destroys an entry in any book or in any report, slip, document, or statement of the business, affairs, transactions, conditions, or assets of that financial advisor shall be guilty of an offense, and shall be liable to a conviction or fine not exceeding $100,000, or to imprisonment for a term not exceeding 2 years, or to both. Appendix. We have summarized a collection of forms mentioned in this chapter for your reference.
If you need to take the CMFAS exam, welcome to explore our study materials. Question bank. Group class. One-to-one tutorial. Passcmfas.online help your success. If you have any questions about the CMFAS exams, please get in touch with us. Office hours. Monday to Friday, 9 a.m. to 12 p.m., 1 p.m. to 6 p.m. Weekends and public holidays, closed. Website, Passcmfas.online. Phone, +65 60111029. WhatsApp, +65 88743947. Email address, info@passcmfas.online.